Put it on silent.
Go ahead, sir.
Ready?
Yes, sir.
Okay, I want to call the May 2nd, 2016 meeting of the Tennessee Auctioneers Commission meeting to order. I'm Jeff Morris. I'll be filling in as chairman since our chairman, Ronnie Collier, is out. If you would, let's call the roll.
Here.
Morris,
Here.
Adam Lewis.
Here.
3 out of 5 is a quorum.
Phillips is absent.
Right.
We have quorum, sir.
But just read the notice of meeting, please.
Notice of the May 2nd, 2016 meeting of the Auctioneer Commission was posted to the Auctioneer Commission website on March 15th, 2016.
We have an agenda today. Gentlemen, you have that in front of you. You got your iPads up and can see it. We need to adopt the agenda that we have today in front of us.
I move that we adopt the agenda. Second.
Moved and seconded. All in favor say aye.
Aye.
Aye. We also have the minutes from the April 4th, 2016 meeting in front of us. We need to review those and adopt them. If you would take a look at that and entertain a motion for that.
Accept. Second.
Moved and seconded. All in favor say aye. Aye. Motion passes. We'll move right into the director's report, Nicole.
All right. If you turn in your iPads to the director's report, you'll see I've posted the...
What page is that, do you know? You don't know.
Last 5 years, budget and expenditures. And then on the following page, I have the current fiscal year information. Budget plan includes for $184,500. Thus far, we have spent $36,633.38. The revenue generated thus far, as of March 31st, 2016, is $162,070.24. The estimated cost backs that will be charged at the end of the fiscal year $56,546.10. The estimated investigative cost is $21,551.71. Thus far, the actual money we've received from complaints is $6,700.
But as I see, you got the 184.5 and you've got the estimated cost backs. We don't know where we're going to end up against that 184.5, though, do we?
Not entirely. Those are pretty good estimates, though. The Education Recovery Fund expenditures thus far has been $82,800. Total revenue for that has been $68,000, and the requirement by statute to be maintained is $150,000, which we have.
What is the current balance there?
The current balance, I'm sorry, I don't think I have that on this month's report, but I believe it was in excess of.
Nice to have that on that report there, if you could.
I'll make sure I add it to next month's
All right,
meeting.
good.
I didn't write it down this time.
All right.
For education information, we have one course that was submitted for your consideration. I'm sorry, I'm just gonna have to get a drink of water. This darn pollen. The Tennessee Auctioneer Association made application for continuing education credit for their June conference. The course instructors are Mark Rosser and David Taylor. The agenda submitted with the course application indicate 1.5 CEU requested for the session taught by David Taylor on strategic planning and public-private partnership and economic development, City of Pigeon Forge. This session The session taught later that morning by Mark Rosser is also requested for 1.5 hours of CEU credit on TRID regulations. This session has to do with the new Consumer Financial Protection Bureau, Truth in Lending, and Real Estate Settlement Procedure Act. Is a consumer protection statute first passed in 1974, and how they could affect auction real estate closing. Please review the attached documents and consider for approval these sessions either as one course as 2016 TAA Summer CE for 3 hours, or as 2 separate courses for 1.5 hours for consideration with the above named course topics. They follow in the iPads.
I get the TRID regulations part of it. I'm not sure what David Taylor's going to talk about from a public planning, strategic planning standpoint. I don't know what that.
No, I read some of this when Nicole sent it to us, or whoever sent it to us the other day. It looked all right to me. As far as the strategic planning and public and private partnerships and economic development, if you're selling something in Nashville, you better know something about it. I mean, good grief, they're always, it's not a bad subject at all.
Okay.
Yeah, it's, with all the building and stuff that's going on,
I would suggest that we do 2 1.5-hour courses versus 1 3-hour.
Second.
Moved in second. All in favor say aye. Aye.
Aye.
Aye.
you know, we've always,
Motion passes.
the way the law reads, I think just here in the last couple of years, we've started doing this course by course or whatever it is, which is fine, but we always have, I think the way the law reads, that we approve anything that's done by a nationally recognized provider.
Right.
Which is like the NAA, and the NAA approves TAA. So as far as I'm concerned, the TAA's and
Erring on the part of caution here. All right, what else you got, Nicole?
I have one that's not in the iPads, but it came in, and I just kind of need the board's opinion on it. I had an application come in from George Wallace. He put his license into retirement, and he now wants to make it active again. He was a candidate that was grandfathered. Now wants an active license. There's nothing in the rules that specifically say how to take a license out of retirement.
How long has it been in retirement? How long was he in the business before that?
if he'd been grandfathered, it had been prior.
Says,
He was in business for 40 years.
yeah.
He probably has enough experience.
So I just need to know what the commission's will is on how do we take him out of inactive status? Do I need to require any education? What do I do?
I think it's in retirement. He stays in that position.
I don't think so either, but by the same token, I don't think it would hurt if he, what is it? Would hurt anything.
In
Especially-
1941.
I mean, things have changed a little bit since.
I don't know.
last-
I don't know what the rules are though in terms of.
Oh, there's not any. We can do whatever we want to do.
Oh,
He was born in 1941, so he would be over the age.
Been retired since '08.
I just need some guidance on how to handle this particular request, because usually people don't come back out of retirement.
Welcome back. I kid.
What's the quickest way to do that?
I think because he has been in the business that long and we have a little discretion here, I think he can put him back active as long as he gets his dues caught up, his fees caught up, and issue him a license.
Okay, then. Next I have for you is a legislative update and a follow-up discussion on if you have any suggestions or thoughts on legislative proposals for the next session. On your iPads, should be just following the information on the education report. House Bill 1810, Senate Bill 22 requires all real estate owned surplus property, either real or personal, to be disposed of at public auction conducted by a licensed auctioneer who is selected through a competitive bid process. Failed in the Business Utilities Subcommittee. Senate Bill 2227 in March 23rd, 2016 was assigned to the General Subcommittee of Senate State.
Sounds like that's going nowhere.
It was a good first attempt.
Make sure you're talking to your mic.
Yeah, I think it was a good first attempt. But
House Bill 1918, Senate Bill 2226, which exempts auctioneers age 60 or older from all continuing education requirements only if the auctioneer has been licensed for 10 years or licensed as of July 1st, 1999, has been signed and will be effective April 7th, 2016.
That answers your question about the earlier gentleman. He's exempt.
All right.
Definitely.
Well, he
actually,
was in
we
it.
found a rule on that as well.
You did?
Yeah. So it's in Rule 0160-01-23, and it says a retired license may be activated upon submission to the commission of a written application. The payment of the appropriate fees is set forth in the rule, and proof that the applicant has obtained at least 6 hours of continuing education in the 2 years prior preceding this application.
Oh, so we do need to see
They're gonna have
that.
to get 6 hours,
Okay.
but then he'll be exempt based on.
Right. Once he gets to 6 hours, he'll be exempt. So that answers your question.
it kind of gets a little bit of it on both sides.
Absolutely.
That's good, I like that.
House Bill 1914, Senate Bill 1571, auctions and auctioneers, authorizes the auctioning of up to 5 motor vehicles a year if the auction of such motor vehicles is incidental to the sale at auction of other properties. It subcommittee in January, and in February it was assigned to the General Subcommittee of Senate Commerce and Labor Committee. Progress.
Right.
I thought they.
Are they out?
Done.
They're done? So that'll be a next year thing.
Actually, I think that's already covered somewhere else in the law. I think that's a reason it. Something in there about that.
Taxes and sales, House Bill 0244, Senate Bill 0036, excludes a community foundation holding 2 auction sales per county receiving charitable support for the definition of business for sales and use of tax purposes under certain circumstances. This also was signed by the governor and it has an effective date of July 1st. House Bill 0433, Senate Bill 0508, Motor Vehicle Commission. This one authorized a person to purchase without having to obtain a motor vehicle dealer license a number of non-repairable vehicles, salvage vehicles, or combination of non-repairable salvage vehicles from an automobile auction if the automobile auction primarily sells motor vehicles on consignment. Governor with an effective date of July 1st, 2016.
That means Copart can sell their salvage vehicles to whoever they want to, insurance vehicles.
I got you.
That's,
Final one is the Right to Earn a Living Act, which is Senate Bill 2469, House Bill 2201. It was signed by the Senate Speaker and the House Speaker in the end of April, and it's been transmitted to the Governor for action. This one, specifically, each license agency by December 31st must submit a copy of all existing or pending entry regulations pertaining to license authority and an aggregate list presented to the chairs of the Government Operations Committee of the Senate and House of Representatives. Requires all agencies to review any entry laws and rules each year and are determined not to be demonstrably necessary, carefully tailored to fulfill legitimate public health, safety, or welfare. Laws recommend to the General Assembly that a law be repealed or amended. By July 1st, 2017, and every July thereafter, conduct a comprehensive review of all entry regulations within the jurisdiction of agency for the purposes of determining whether each entry regulation serves a public health, safety, or welfare objective. If the entry regulation does not, the agency will be required to repeal or modify. Any person may petition an agency to review, repeal, or modify an entry regulation and must review within 90 days by the agency. The agency is required to repeal the regulation, modify the regulation to serve a public health, safety, and welfare objective. The basis on which the agency concludes the regulation serves a public health, safety, or welfare objective. That concludes the legislative update, and I'm going to turn it over to Sarah to talk about the legislative session for next year.
Okay, so I sent you all an email on Friday evening. I don't know if you had a chance to look at it, but basically we need to discuss anything you want to propose to go to the legislature to be included in our statutes. They want to get this done as soon as possible so we can send it through the right channels and make sure we're not missing anything, or if they think we're completely out of line with what we suggest, they'll let us know. But basically that's all we need to do is just have a discussion on what you all think needs to be included in the statute, or if there's anything you guys think needs to come out, or.
Hey, Bobby.
I had a couple of mine and I forgot them. I thought of them this weekend, but,
What's our deadline for getting you something?
I need to get something by the end of next week, just kind of written up. So that kind of gives you guys some time.
we email you.
As long as it's to me only. So that way there's not multiple people weighing in on it.
Right.
Well, I think, ain't that what we want? I mean, that's what we're going to do today, and that's one of the reasons I'm hesitant to talk about it today is because everybody's not here.
Yeah, and that's,
Yeah, I mean,
Law.
we could have a brief discussion today, and I could
I
talk
don't know if that would really
to
have anything to do with that.
Mark Green about possibly, since we do have a meeting next month, if we could push it to next month, just so that we can get everybody here and kind of give you guys some time to think about it and make some notes. And yeah, and if I explained to him that there were only 3 of you here today, and we just found out about this last week as well. So, and in addition,
A lot of laws and stuff that get made are just because 1 or 2 people wanted them. You got a couple of examples right here in what you just read us, and that's not always necessarily a good thing.
and next month I actually should have a very comprehensive legislative update from this last session. They're going to come meet with all of us about what affects our boards, and so I should have something a little more detailed.
I would like some background on that last one The right to earn a living.
The right to earn a living. It's going to
That's-
create a lot of work for me is what
Well,
it's going to do.
And it's a bill to get some votes.
Yeah, it's basically, I mean, it could get rid of some boards that don't, serve the health, welfare, and safety of Tennessee residents.
I had two different auctioneers. There was a newspaper article in a paper in Knoxville that, I can't remember who it was. There was someone talking about this law. And I can't remember exactly what it was. I could probably go back and find it. But they said something that it makes it hard to do business when you got to wait 2 years to be an auctioneer. Well, that's not the way it is. You're an apprentice for 2 years, and then it said, and why do you have to go so many hours to be a manicurist? But it threw auctioneers in with some other things. And, one of the big things that was a big difference to me, and all of it, was handling other people's money. And we handle other people's money. Auctioneers handle other people's money. I don't know whether a manicurist does or not, but they weren't comparing apples to apples.
Yeah.
And there was a couple of auctioneers just got tore all pieces, saw that newspaper article and sent it to me, and then I checked on it and found out it was a done deal, so.
Yeah, and I didn't check this morning, but it will definitely be signed by the
Yeah,
governor.
it's a done
So,
deal. Yeah,
I mean,
it's a done deal. So, but it was just, I don't know.
yeah, I don't know that it'll affect this board as much as it'll affect some other boards, but it's definitely going to create some stir to have to go through and do this every year and kind of reevaluate what you're doing and why. But other than that, on legislative updates, did you all see that you had a National Auctioneers Day
Yes,
in
we did.
Tennessee?
Yeah.
Congratulations on that.
And we have it every year.
Yeah, Jenica and I ran across it when we were looking at it. We were like, oh, this is nice.
That's,
Is that it for your report, Nicole? You got anything else?
just have one last thing, as a follow-up from last meeting, just a couple of points of clarification. We were talking about the Nashville Auction School, and just a couple of things I need to clarify. One is that they hold 3 sessions each year, and the other is that they don't charge any of their students. I think there was a little miscommunication on.
I think we knew that.
I just wanted to make
yeah, I
sure
think we
that
knew
everyone
that.
understood that they don't charge their students for those
Yeah, we
those
knew. I think we
sessions.
knew.
So that's it, and that concludes the director's report. After that, just a short legal report, and we'll be on to the next item on the bid.
I'm going to say we should be able to get through this before Adrian gets here if we want to go ahead and do the legal report.
Let's do.
Okay. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. 2016009711. This matter is being represented from the April 2016 commission meeting, at which time the commission authorized a civil penalty in the amount of $1,000 for unlicensed activity. The facts of the case were presented as follows. The complaint was filed by a licensed auctioneer and alleged that respondent was conducting unlicensed online auctions. Complainant stated that the respondent is running an online auction and closing time to bid on items is extended. Counsel reviewed the respondent's webpage provided by the complainant, which explains how its online auctions are conducted. According to the webpage, respondent's system is set up where if any item gets a bid in the last 2 minutes, time will be extended by a couple of minutes to prevent anyone from getting sniped. After the April 2016 commission meeting, it was discovered that the complaint was not sent to the respondent, providing respondent with the opportunity to respond to the complaint. Respondent stated that respondent has been compliant with TCA 62-19-1039 since the commission inquired into the same situation in July 2013. Complaints number 2013-00971 and 2013-01268. Respondent states that since July 2013, all online auctions are fixed-timed auctions. This is stated in the terms section preceding the auction lots, stating in part that auctions have fixed end times. There are no extensions, even if there are bids in the last minute. In regards to the respondent's webpage, respondent states that the text in question was simply the use of an outdated FAQ, and respondent corrected it promptly upon receipt of this complaint. Respondent again stated that the text from the webpage does not reflect the actual conduct of the respondent's auctions. Council has reviewed the respondent's webpage, and it has been updated and now states in part, "When does bidding end?" For most sales, bidding will end after the first day of the tag sale, which allows people to view items on day one. The website will show a timer on the last day so you can count it down. Items end when the timer runs out. There are no extensions, even if someone bids in the last second. Respondent would like to apologize for any confusion the text on the webpage may have caused and appreciates the efforts of the complainant for bringing this error to its attention. Additionally, counsel spoke with the respondent and confirmed that after the July 2013 complaints were filed against the respondent, the respondent changed its online policies. My recommendation is for this matter to be discussed further by the commission.
That's the only way that we have to look at these things based on the eBay law, that if there is any extension of time, then it becomes a live auction. If there's no extension of time, and we're sure there's no extension of time, I think they fall within the law as written. One of those things I wish we didn't have, but that we have what we have, and the legislature has spoken. Bobby, you have any comments about it? Or Adam?
Pretty much it.
Motion on this, there's really no action other than we're going to, it is what it is. There's nothing else left to do unless you'd like to first
So
vote.
we're going to dismiss this and not do the $1,000 civil penalty that we did last month.
Take an action on that.
So
we
you need a
can.
motion to
right.
dismiss.
Motion we dismiss.
Second.
Made and seconded. All in favor say aye.
Aye.
Aye. So yes, it's dismiss the case and waive the $1,000 fee. Much to my chagrin.
Okay. 2016007281. This complaint was filed by two consumers, Complainant 1 and Complainant 2. Complainant 1 alleges that respondent starts auctions by stating there is a $1 minimum bid, and the seller's consigners are allowed to have only 2 reserves during the auction. Complainant 1 alleges that respondent puts a reserve on his personal items for a minimum bid of $10 or $20. Complainant 1 alleges that respondent allows sellers or consigners to bring stuff up front and sell and places a $5 minimum bid on those items. Complainant 2 alleges that he consigned 3 tables at one of the respondent's auctions, and that respondent represented that he wanted to sell the tables one at a time as cheap as he could. Complainant 2 alleges that respondent placed a reserve of $5 or $10 on his personal items. Office of Legal Counsel requested an investigation, which yielded the following information. On March 29, 2016, investigator received communication from complainant that the auction house had burnt down and was unsure if the auction barn will ever reopen. Counsel's recommendation is to dismiss.
Discussion.
Want to sell the tables one at a time as cheap as they could. Okay. I move we go with legal's recommendation.
Motion's been
Second.
made and seconded. All in favor say aye.
Aye.
It burned out.
2016016361 and 2016016362. This complaint was filed by a consumer and alleged that respondent failed to stop bidding at $110 after the bid was not challenged or increased by another buyer. The bid went up to $150. On or about March 4th, 2016, complainant alleges participating in an online auction held by the respondent. The complainant placed bids through auctionzip.com. Complainant alleges that he placed the high bid on a lot for $150. When the item came up for bid, the bid increments were in $10 increments. Complainant alleges that the respondent acknowledged a bid of $100 from another online bidder, and that complainant's top bid of $150 allowed for the clerk to bid $110 on behalf of the complainant. Complainant alleged watching online as the auctioneer repeatedly asked for a bid of $120 and there were no other bids at that point, and respondent proclaimed sold to online bidder at $150. Complainant alleges surprise when bid went from $110 to $150 and no one else bid on the lot. Complainant alleges calling the respondent on March 7, 2016 to inquire as to how the bid went from $110 to $150. Respondent's employee explained that this situation has occurred before and that complainant needed to contact AuctionZip because it was a problem with their computers. Complainant alleges calling AuctionZip and speaking with a representative who explained that this was the fault of the respondent's clerk who enters the bids from AuctionZip. AuctionZip maintained that the clerk failed to lodge the bid of $110 as the highest bid, and respondent then hammered down the $150 top bid. Complainant alleges that AuctionZip told him that there was nothing they could do for the complainant. Complainant alleges calling a respondent back, at which time the respondent's employee agreed to conference call with AuctionZip. Complainant alleges that during the conference call, both AuctionZip and the respondent's employee blamed each other for the problem and neither party would take responsibility. Complainant alleges that what should have cost the complainant $132 cost the complainant $177, essentially an overage of $48, $40 in cost and $8 in commissions. The complainant asked for a refund of the $48 from the respondent, but the respondent told complainant that they had no responsibility in the overcharge. Respondent stated that the auction was held on March 4, 2016, and it was an absolute consignment auction. Respondent states that at the auction center there is a live crowd and also many people registered to bid online through AuctionZip. Respondent states that complainant is disappointed that the item was purchased for $150, but the complainant agreed to $150 when he entered that price into AuctionZip as the maximum bid. Respondent states that complainant claims that no one else bid on the item between $110 and $150, but as the auctioneer, respondent states that he could have easily accepted bids from the floor during that time in which the price increased. Respondent states, since this complaint was filed 2 weeks after the auction, it is almost impossible for a respondent to remember exactly what floor bids were taken at that time. Respondent states that complainant neglected to include in the complaint that respondent provided complainant with the option of canceling the sale of the item and therefore would result in no charge to the complainant. After giving this option, the complainant still wanted the item and agreed to $150. Respondent states that out of respect, the price of packing and shipping of the item were waived. In addition to respondent's statement, the clerk of the online bidding portion of that auction provided a response. The clerk stated that there were only 2 ways in which the complainant's bid went from $110 to $150. Either the floor was bidding or another online bidder was bidding. The clerk explained that technically there is no possible way to jump the client's bid. Council recommends we dismiss due to no violations.
There's a lot of money and time spent on a $48 item.
I move that we go with legal's recommendation.
Motion's been made.
Second.
Made and seconded. All in favor say aye.
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 2016014091. This complaint was filed by a consumer for bad check. Complainant alleges that on Saturday, October 17, 2015, complainant took a pickup truck load of used furniture and collectibles intending to run through the auction that night. Complainant alleges that respondent offered $275 for the merchandise. Complainant alleges that respondent wrote a check for $275 and gave it to the complainant's roommate for a rent payment. Complainant alleges that complainant's roommate deposited the check and the bank informed them that it was not good. Complainant alleges that they had to pick up the check from the bank and it was $275 plus an additional $30 service charge. Complainant alleges that other people have had the same problem. Respondent stated that on Saturday, October 17, 2015, complainant brought some things to sell at the auction, and that respondent told complainant that the auction wasn't good at that time and people may not want to pay what complainant thought it was worth. Respondent states that the items did not bring a lot and complainant got mad. Complainant threatened that respondent was a crook. Respondent wrote complainant a bad check and it bounced. Respondent states it bounced because at the same time respondent had someone write them a check for $2,000 and it also bounced, causing the escrow account to be a mess. Respondent states everything was straightened out with everyone but complainant because he had moved to another state and respondent didn't know how to get in touch with him. Respondent states they had every intention of making things right but lost contact. Respondent states that if they could get complainant's address, they would pay him. Counsel called respondent to ask if, since receiving a copy of the complaint, had respondent attempted sending the complainant a check. Respondent informed counsel that they had not yet mailed the check, but would mail the check that day and send proof of mailing to counsel. Respondent mailed the check for $340 via certified mail on March 31st, 2016, and sent proof to counsel via fax. Counsel recommends a letter of warning regarding TCA 62-19-112B4, which states in part, failing to account for or remit within a reasonable time any money belonging to others that comes into the licensee's possession.
Discussion. Well, it's clear on this that he got a check for $2,000 that wasn't bad, so his escrow account checks bounced as well. That's always a bad place. Does need to make sure that he has a way to cover that. So, Bobby, got anything to say about it? Everyone entertain a motion.
I'd move we'd go with legal's recommendation.
Been moved.
Second.
Seconded. All in favor say aye. Aye. All right. Motion passes. That's it for the legal report.
Yes, and I'll send Mark Green an email today about the legislative proposals for 2017, so we can move that to next month.
All right, perfect.
Good, thank you.
If you get that out in an email to everybody, that would be great, so that they
Yeah,
can
I'll
kind
send
of
out a
get their
reminder.
notes put together and make sure they're here.
Absolutely.
So do we need to adjourn this and re-meet for the formal hearing, or just adopt it, the formal hearing right into it? How do you want to do that? And before we start, I think we'd like to take a 5-minute break, if you don't mind. And everybody take a bathroom break, and we'll be back here in 5 minutes.
I'll do my best.
Good morning, Commissioners.
Okay. Ready.
This is a hearing before the Tennessee Auctioneer Commission to consider the matter of the Department of Commerce and Insurance Division of Regulatory Boards versus John Keistler, doing business as Hillbilly Auction. My name is Tom Stovall, and I have been assigned by the Secretary of State to be the administrative judge at this hearing. The judge will not participate in the decision that is made on the merits of this case.
Honor,
Those
would you
members.
bring that microphone a little closer to
Okay,
you?
would those members please identify themselves for the record?
Yes, I'm Jeff Morris.
Bobby Colson.
Adam Lewis.
Thank you. Members of the commission are reminded that their decision in this matter must be based only upon the record that's produced during the course of this hearing this morning. Failure to abide by this instruction could result in the matter being reversed or remanded back to the commission for further consideration should it be appealed to Chancery Court. I'd also ask the members of the commission at this time if they have received any ex parte communications concerning this matter, or if they have any prior knowledge about this case or the underlying facts, or any familiarity with the respondent, Mr. Keith.
And for me.
I don't.
Let the record show that Mr. Adrian Trick, Assistant General Counsel with the Department of Commerce and Insurance, represents the department in this matter. Our record also show that the respondent, Mr. Keistler, is not present, nor is an attorney present on Mr. Keistler's behalf. And I understand that Mr. Chick is going to make a motion to hold him in default. Before we get to that, why don't we just pause for a moment and allow the commission members to review the document that was passed to you. This is the amended notice of hearing and charges that was filed on February the 5th of 2016. The original notice of hearing and charges was filed on January the 29th of 2016. So go ahead. Right, it appears that the commission members have had an opportunity to review this document. And I will also state for the record that in addition to the notice of hearing and the amended notice, we also have a notice of witnesses and exhibits filed by the department on April the 25th of 2016 and a pre-hearing order that I entered on April the 13th of 2016. Mr. Chick, based upon my conversation with you prior to us going on the record, I understand that you intend to make a motion to hold. Is that correct, sir?
Yes, sir, I do. I so move and ask that they proceed with the hearing.
All right, do you have proof of service in this case?
Yes, sir, I do.
Mark this as exhibit number 1. All right, Mr. Chick, have you had any communication with Mr. Kiesler on the phone or email or
No, sir, I've not had contact with Mr. Kiesler.
But you,
But he.
I'm sorry, go ahead.
That is what Your Honor's looking at is where he was served with a notice of the hearing and charges for today.
all right.
That was a personal hand delivery.
The amended notice.
Yes, sir.
Okay, so that was the service of the amended notice, correct?
Yes, sir.
Okay, all right. All right, members of the commission, it appears that Mr. Kiesler has received notice of this hearing, and therefore I will turn it over to you to determine whether or not you wish to hold Mr. Kiesler in default and allow Mr. Chick to proceed with this case uncontested, or if you wish to deny that motion and continue the case until the next meeting of this commission, and if Mr. Kiesler will appear at the next meeting.
Question, Your Honor. So the service was given, you've had no calls, no written or verbal or email or anything from the defendant?
That's correct, Your Honor. Well, Commissioner, that is correct. I anticipate some difficulty on the front end making contact with him, which is why I had our investigator go personally locate him. And
No reply whatsoever?
no, sir.
Okay. Well, I think the chair can enter discussion or entertain a motion that we find the defendant in default and accept the motion by Mr. Chick.
You hadn't made your motion yet, have you? Or
Yeah,
you
yes,
have?
sir.
Yes, sir.
Okay. So, I move that we, since how he was served, I think we have proof that he was served.
Right.
And, that we continue on with.
All in favor, say aye.
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 All right, very good. Mr. Keesler is held in default by the commission, and Mr. Chick, you're allowed to proceed with your case. Do you have an opening statement you want to make?
Well, this is a case where the allegation is, and good morning, Commission members. The allegation is simply that the respondent, John Keesler, operated a unlicensed auction gallery where he did sales of small items. Mr. Keesler at one time had a apprentice auctioneer license, but that expired long ago, and there's never been a gallery or firm license for that location. So that's.
Do we know whether he's still in business or not?
Well, I think I'll answer that once I get into
Okay.
that.
All right, thank you. So, go ahead, Mr. Chick. Call for first witness.
All right. Well, Your Honor, if I may, as Your Honor is aware, with the Department of Commerce and the Insurance Division of Regulatory Boards under Title 56, we're required to provide administrative support to these boards and commissions such as this one. That includes investigation. We're also required under Title IV, Chapter 5 of the UAPA to maintain records. So one of the things that we did upon receiving a complaint is had an investigation of this allegation done. And I would like to tender this investigation report as a record of a regularly conducted activity. It bears the seal of the state of Tennessee on it, so I believe it's a self-authenticating document.
And this is produced by your investigator, is that correct, sir?
Yes, sir.
And again, based upon the conversation that you and I had before the commencement of the hearing, this investigator is not present this morning, is that correct?
That's correct.
All right, okay. We'll allow this to come in as exhibit number 2.
And if I could, I would like to give the commissioners just a few minutes just to read through it.
Correct. All right, so we'll allow them time to do that. This will be marked as exhibit number 2.
This is actually the report from the investigator.
Yes, sir.
Right. Okay, thanks.
the commissioners had an opportunity to review these documents. All right, Mr. Chick, go ahead, please, sir.
All right, so we made that as the Exhibit 2, correct?
Correct.
The witness I'd like to call is Miss Nicole Avers.
All right, Ms. Avers, would you raise your right hand, please? You swear the witness.
You swear from the testimony you're about to give in this matter be the truth, the whole
Morning, Miss Avers. Can you say your name, spell your name for the record, and tell us what you do here?
Nicole Avers, Nikoleavers. I'm the Executive Director for Regulatory Boards. I oversee 17 commerce and insurance.
Miss Avers, are you familiar with a individual named John Kiesler?
Only as a respondent in this case, yes.
And same with Hillbilly Auction, are you familiar with that name?
Yes, only as a respondent in this case.
Is John Kiesler a licensee of this board?
No, he's not.
Do you know whether he has ever been a licensee of the board?
Yes, he was. He was an apprentice auctioneer from 2006 to 2008.
And what about Hillbilly Auction at the West Broadway location? Has that ever been a licensed firm or a licensed gallery?
There's never been a firm by the name of Hillbilly Auctions at that location.
All right, those are the questions that I have for Ms. Avers.
Members of the commission have any questions for Ms. Avers? All right. Thank you very much, Ms. Avers.
I had some documents that the paralegals make some copies of. We expected in them that they would be discussed by another witness, but if Your Honor would indulge me with 2-3 minutes, we'll have those.
Thank you.
You do anything at this point?
You're just making copies, right?
Yes,
Is that-
I mean, she'll be back probably literally within 2 minutes.
All right, we'll just wait.
I know most of
Wait.
the time when attorneys say 2 or 3 minutes, that means
2 or 3
half an hour,
hours.
but,
Yeah.
yeah.
Curious as to where Newport, Tennessee was.
I believe it's up
That's
past
David Cole country. That's,
Way up on,
Pigeon Forge in Knoxville, I believe.
we had
barely inside the state of Tennessee.
a convention up there one time. They got a big convention center up there, real nice.
In Newport,
I
Tennessee.
swear. Maybe that was Kingsport.
That's
No?
Kingsport, yes. That's
Maybe
not,
it was.
that wasn't Newport. They barely got a road that runs through Newport.
No, I tell you who used to be from Newport. You remember J.B. Steiner?
Can this part be off the record for this? Okay.
You're not typing all this, are you?
We're
I
in
don't know
the,
what they're gonna say.
That's who was from Newport. Guess we're waiting on you.
Okay.
oh, Memphis had that,
Yes.
Okay. Your Honor, what I have here are some documents that I thought that the witness, the inspector, would talk about, but I believe that there's grounds under the rules of evidence to get them anyway. These are, I'm just gonna show it to the judge right now. As far as hearsay, those are things that are showing advertising different auction dates. I don't believe it's actually hearsay because it's not relevant for the truth of the matter asserted, and
Well, we
if
don't.
anything, it's against interest.
Well, we don't have, the respondent, Mr. Kiesler, chose not to appear to defend this case, and so there's nobody here to object to the admission of any documents. So I'll allow it to come in. I will ask one question, Mr. Chick. I noticed on here that it is entitled Hillbilly Sales, but it says Johnny Kessler, Kessler, and the same address. Are you aware? I'm assuming we're talking about the same individual here.
Well, Your Honor, I believe we are. We've had a couple of different spellings. The spelling that we've used in our system is the Keistler, and
Okay. All right. I'll allow this to come in as we'll mark it as exhibit number 3. And do you have copies for the commission? Okay.
And what I'd like to.
Hang on, Ms. Chick. Let her mark this, please. Okay.
What I'd like to do with this document, Commission members, is illustrate that it's an advertisement for some 15 separate auctions, if you count those different dates. Okay, so that is the state's evidence. That's all the state's witnesses and the state's case, Your Honor, to show the
Have a
unlicensed.
closing statement you want to make to the
Yes, sir. I'd like to
commission?
make a closing statement, and this tracks very, very closely to what's in the notice of hearing and charges. As the commission members are aware, under Tennessee Code Annotated 1619-125, a license is required to operate a separate gallery, and there's been testimony that there's none here. And second, the statutes also require that a person be licensed as an auctioneer to engage in auctioneering, and that's not the case here. He's not licensed, so maximum civil penalty that can be imposed by this commission is up to $1,000, and there's a number of factors the board could consider, such as deterrence, and I would refer you back to the investigation report that you read, where it mentioned that he had done this before, he didn't pay the civil penalty, and he's going to keep doing it. So I think those would be good factors to consider that would provide a good foundation for imposing the maximum civil penalty of $1,000. So the state would ask that a $1,000 civil penalty be assessed against his auctioneer license, against him for not having an auctioneer license, and that a civil penalty of $1,000 be assessed against him for not having a proper gallery license, and do that for each of the 15 auctions that we're sure that. In fact, let's make it. Stay with 15. That's what the state would ask. So that would be $30,000 total. That would be 30 different violations. And very importantly, I'd ask the commission to please make a finding that all the cost of this hearing and investigation are assessed against the respondent as well.
All right, Mr. Chick, do you have a proposed order for the commission's review?
No, Your Honor, I don't. What I would asked them to do is just use the allegations of fact as their findings of fact and use the alleged violations for their.
All right, very good. All right, members of the commission, let me make a few very brief comments to you in the form of a charge, and then I will turn it over to the chair to conduct the deliberations. It's the responsibility of this commission at this time to make a decision. That decision will be the final order of this commission in this matter. The final order must contain findings of fact, conclusions of law, a determination as to what, if any, discipline is appropriate to be imposed in this case, should you find any violations of the law, and reasons for your decision. The burden of proof is on the department to show by preponderance of the evidence that the factual allegations contained in the amended notice of hearing and charges are true. And the burden of proof is also on the department to show by the preponderance of the evidence that the facts established in this case constitute a violation of the statutes and/or rules as are set forth in your notice. I agree with Mr. Chick that it might be helpful to the commission to use the amended notice of hearing and charges as a guide during your deliberations, and you make a determination based upon the evidence that you heard this morning whether or not the facts set forth in the notice that it begins at paragraph 7, allegations of fact, have been established as true. Should you find by your findings of fact, or after you make your findings of fact, you would then, I would suggest that you move to the section entitled Alleged Violations, which sets forth the statutes and rules that the department is arguing that Mr. Kiesler has violated in this case. After you make your conclusions of law as to any legal violations that you deem have been established in this case, it is then your responsibility to make a decision as to what, if any, penalty is appropriate in this case, as is set forth in paragraph 10 and 11. The commission is authorized to assess civil penalties in this case against an unlicensed individual and as Mr. Chick says, against an unlicensed gallery. The maximum civil penalty is $1,000 for each violation of the statute and/or rules. The state has asked for a total of $30,000, $1,000 penalty assessments against both Mr. Kiesler and for operating without a license, and also against for operating a gallery without a license. It, of course, is totally within the discretion of this commission to determine what civil penalties, if any, are appropriate. Mr. Chick has also requested that the costs of this proceeding be assessed against Mr. Kiesler. As I previously stated, as the administrative judge, I don't participate in the decision that's made in this case. That decision is to be made by the members of the commission. However, I will be available for any questions that you might have during your deliberations. And if you have no questions of me at this time, I'll turn it over to the chair.
Thank you, Your Honor. We do have allegations of fact in front of us. I think we've looked at them. We've heard the state's evidence. Is there any discussion about the allegations of fact that we have in front of us, or any comments that you'd like to make at this time? It appears to me that he clearly has been holding auctions. We only know of the 15. We don't know the ones before, the ones after, and there probably were some before and some after, but we know of the 15 cases that were advertised. It's clear from the website posting on auctionzip.com, where he has invited the public to attend his sales and participate. And it says we have great vendors come in from all the time with great new items. So he has clearly taken items on consignment. This is clearly not his own stuff from my looking at what he's been advertising. So he is in violation, in my opinion, as to holding a public auction. And it's also clear from the evidence from the executive director that he does not have a license, has not had a license during the time that he has been holding these auctions, and by his clear absence here today of not having an intent of obeying the law as we have in our statute.
And previously having an apprentice license, that tells me that he knows that he's supposed to have one.
Right.
And first thing we need to do is the findings of fact.
Yes, sir.
Okay. That be the evidence that
Well, if you start with paragraph number 7, he's basically, the respondent, Mr. Johnny Kessler, or Kiesler, depending on how you want to spell his name. That's a little concerning that he has two different spellings of his name. One that he has on the website is Kessler, and one in the complaint is Keistler. But they're both doing business as, one is Hillbilly Sales and one is Hillbilly Auction.
do we know which spelling he had when he had an apprentice license? I'm asking
Ms.
Avers.
Avers, let's go back into the hearing at this point, and I do think this is a legitimate question. Ms. Avers, can you respond to that?
Yes, I can. When he applied, it was with the K-E-E-I,
Aye.
yeah. Of the documents, and that's how he spelled it. And if you look on the green card, he spells it that way when he's.
We'll stay with the Keistler.
You know what I was just thinking, though? It might be wise in the final order, if the commission agrees, and I guess since Mr. Chick would be drafting the order, if perhaps both spellings were included in the
AKA.
That's kind of what I was
yes,
thinking.
AKA, right?
Right.
Okay, go ahead.
So in our finding of facts, we do find that Mr. Johnny Kiesler or Kessler, however, did in fact hold at least 15 public auctions without a license, and it is in violation of the Tennessee Code
6219.
6219-125, and Part A that requires anybody to own or operate an auction house or auction barn, auction gallery, or any other type of auction operating at a fixed site for purpose of selling consigned or purchased goods at a fixed location is required to first obtain a gallery license. So we can find that he does not have a gallery license, and he's in violation of that code.
That might come under statutes
and
and
also-
rules. First, we need to do our findings of fact.
And also, it's in violation of 6219-102, in lawful for any person to advertise to be an auctioneer, apprentice auction firm, without holding a valid license. So he's in violation of both of those code, TCA code 6019-102 and 6219-125.
I think that's the second part, though. I think we've got to give our findings of fact first, don't we?
I mean, we're finding the fact that he did operate in, from my standpoint, that he did operate without a license under either.
I think the state proved that with the investigation and the stuff off of Auction Zip and.
I have a question.
All right.
It's only mentioned, I think, just briefly, but who is Tim?
Yeah, that's a good question.
Tim's listed. Please call Tim at 4. Well, the phone number's there. As part of the Auction Zip advertising. Do we? According to the statement by the investigator, Tim, the respondent stated that he doesn't really know who Tim is. Is that?
And we don't either. So.
I think at this point, I think you need to just base your decision on the evidence that you've got in front of you.
Fair enough.
And I agree, as you go back, I agree with Mr. Colson that probably the easiest way to do it is to just follow the allegations of fact and adopt them, or make any modifications or additions to these facts that you
we
think
do
have been
that?
established. in
Let's
this
do
case.
that form of
By motion?
Yes,
Form
yes.
of motion. Okay, I move that we adopt the state's allegations of fact as our findings of fact, that respondent Keesler and Kessler advertised, arranged, and managed and carried out auctions unlicensed.
Second.
Been moved and seconded. All in favor say aye.
Aye.
Now we go to the part about the laws, I think.
Your Honor, I'm sorry. Could I request that the commission specify the number of?
Yes.
violations?
Do we do that in the findings of fact, or do we
Well,
do that in the next
I just
section?
noticed, I just said for
It
each
probably
instance,
would
but-
be, I'm assuming you're talking about where you say Friday and Saturday nights of every week. Is that what you're talking about? Because I think the state has alleged 15, and if you think, I haven't counted them up, but if,
I counted them.
what you might want to do then is you might want to amend
I would like to amend my motion.
to say that there were 15, if in
That there were
fact.
15 violations that we know of. That the state proved there were 15 violations.
Well, I think what you might do in your facts is just to say that that the respondent carried out 15
unlicensed
unlicensed auctions on Friday and Saturday nights of every week between March 6, 15 and September 26, 2015. Would that get it, Mr. Chick?
I need to say that or do?
Yeah, why don't you?
Okay. All right, I would like to amend my motion, and I think the state proved that between April 25th, 2015, and
Actually, it's March 6th.
September 26th. Is that all of them? 1, 2, 3, 4, 5. And September 26, 2015, that Hibbily Auctions, John Kessler or Keesler, had 15 unlicensed auctions
As auctioneer and gallery, right?
as auctioneer and gallery.
So it'd be really 30 violations. Right.
Right.
We have 30 violations, 15 as auctioneer, 15 as an auction house between April the 20,
April 25th.
April 25th, 2015, and September 26, 2015, where he acted as auctioneer and gallery. So
Sorry, I count more than that. One
I
of
was
these
look-
pages
well,
is out of order.
Some of them kind of swap over to the next page.
Yeah.
If you look at them, there's 1,
All of the
2,
dates.
3, 4,
It goes page 1, page 2, page 4,
5,
page 3.
6, 7, 8,
So
9,
if you count
10,
page 3 in
11,
order,
12.
which picks up on July 25th, there's actually more than just 15. 4, 5.
You're right.
I count 23
There's 16, 17, 18.
advertised sales.
You are correct.
or 23. Do you want to make that amendment to your motion?
On the next page over there, I thought that was the end of it when it, on the copy.
Yeah, there's 23. And
All right, who made these copies?
That's why I can't do it.
All right,
Do we know these are all,
yeah, that he had
are they all
auctions on
separate?
all
That
these.
we didn't make
And-
copies
And
of,
actually, if you look on the allegations of fact, it reads March the 6th, that's where you got that a while ago.
Right.
To September 26th.
I don't see a March the 6th.
There's March 6th
On
don't
March.
show
It's in
on the,
yeah, we don't have any evidence as to those dates.
yeah.
If I might make a suggestion to the commission,
Please.
Please, Your Honor.
If in fact you believe that it has been established that there were 23, that one thing you might do is, and there appears to be a little unclear, at least to me, as to the dates. You could simply say that in 2015 he conducted 23, or advertised at least 23 different auctions in 2015, unless you're confident that you know the dates involved. It would get you to the same place, but in case there's a discrepancy on the dates, that's just a suggestion.
You just say based on the evidence provided, rather than having to list dates?
I think, yeah,
Yeah, you could leave the specific dates out
Okay.
and
Yeah.
just say that in 2015.
I move that in 2015, the respondent, DBA Hillbilly Auction, advertised, arranged, managed, and carried out auctions at 324 West Broadway, Newport, Tennessee, at least 23 times. Unlicensed auctioneer and an unlicensed gallery.
Second.
It's been moved and second. All in favor say aye.
Aye.
Aye. All right, so we have the
Findings
allegations of fact.
Findings of fact.
Dick, are you all okay then, since you all are going to have to be drafting the order? Are you
Yes,
clear?
sir, I might, if the commission doesn't mind, split those into separate ones for the auctioneer and gallery, but that sounds good.
Okay, all right.
All right, so now we need to find the violations based on those facts. We have an alleged violation that for each instance in which the respondent advertised for the auction and managed the auction or carried out the auction, as we have found, that he is now in violation of Tennessee Code 6219-125 and 6219-120 under those separate 23 counts on all of those. We need to find motion or have a motion saying find that it'd be in violation of the Tennessee Code law.
Is this where we assess the penalty?
No.
First, you need to find the violation.
Yeah.
Then you assess a penalty.
Next step would be-
I move it the state prove that Mr. Kessler and Hillbilly Sales Auction violated 6219-125, TCA 6219-125.
Sixty-two 19-102.
6219-102.
Second.
Moved and second that we have found him in violation of both Tennessee Code 6019-102 and 6219-125. All in favor say aye.
Aye.
Aye. Now, what we need to do is for under our rules and regulations, we have a civil penalty that we can assess up to $1,000 for each violation, which we now have 46 violations, counting 23 as auction gallery and 23 as auctioneer. And the chair will entertain a motion as to what the civil penalty will be.
I'd like to motion $1,000 civil penalty for the 23 violations of not having an auction gallery, and a $1,000 penalty for the 23 violations of not having an auctioneer license, for a total of $46,000 in civil penalties, plus costs of today's hearing.
Added to that. Okay, it's been moved. And
Oh, second.
seconded by Bobby Colson. All in favor of that, say aye.
Aye.
So we have an affirmative on the 23 times 2, which is 46 times $1,000 plus the cost of the hearing that we have today as being the assessment for the penalty. Your Honor.
And the only thing left is you need to make a statement as to the policy reasons for your decision in this case.
If I can, I would just say that it has been the consistent and steady argument from this commission that we are here to act in the commission's behalf, in the public's behalf, in their protection, and that any charges that we have before us and any civil penalties assessed that we give out are in the pursuit of the protection of the public to keep auctioneers from violating the law as set forth by the Tennessee legislature.
That require a second, or is that just a statement by us? Very well stated.
Nothing further, we'll stand adjourned. Thank you, gentlemen. Thank you.
Thank you.
Tell Mr. Phillips that if he'd been here, it would have taken us 2 hours.